Okay, so this is the next video in our series on the Pennsylvania criminal process. And today we are talking about the first hearing that has any substantive effect on your case. That hearing is the preliminary hearing. So first things first, what is a preliminary hearing? What is the purpose of it? What are the rules at this hearing? What should you do before your preliminary hearing? These are some of the questions I'm going to try to answer today. So first things first, a preliminary hearing is a hearing that's scheduled in every criminal prosecution, in most criminal prosecutions. And the purpose of it is to determine whether the state has probable cause to have filed charges against you, to determine that these charges, these accusations, are not completely arbitrary. One might describe it as the allegation phase of the criminal case. It's all about the allegations. And so in today's video, we're going to talk about what this hearing looks like, because there's a lot of confusion. A lot of people tend to conflate this hearing with a criminal trial. That is not what this is. This hearing, like we talked about in other videos, it is done in front of the local magistrate judge. There is no jury there. There's no requirement that the Commonwealth prove these offenses against you beyond a reasonable doubt. And there are a number of specific evidentiary rules that are in effect at this stage that don't apply at future proceedings. So what do you need to do before your preliminary hearing? So at this point, you know that you've got a criminal complaint. It's either been mailed to you or it's been given to you by the police officer that filed charges against you. So like we said in the past, get an attorney, lawyer up as soon as possible, okay? Whether it's hiring a private defense attorney or whether it's getting an attorney appointed to you at the county for which the crime allegedly occurred, do that as far in advance as possible. And this is very important because your attorney is going to need time to speak with you about your case, to find out some background about you, but also to get your side of the story. Because remember, the attorney, all they know about the case is what's in the affidavit of probable cause. They haven't heard from you, and they were not there the night whatever the allegation was. So read your complaint, read it multiple times, okay? Make sure you know, pull the code section and read the statute that you're allegedly charged with. Make a list of the elements that would have to be proven at this preliminary hearing. And look through the affidavit of probable cause and try to guess how they're going to try to make out their case based upon what they're articulating in the affidavit of probable cause. Because if you have a hearing, it's likely that the testimony is going to be substantially similar to what they wrote in the affidavit of probable cause, at least for the officer. So after you've done that, you prepped, you got your attorney, you reviewed your affidavit of probable cause, maybe you got some arguments, maybe you don't, to get it dismissed at this stage, and we'll talk about why. So what we're going to move into next is this preliminary hearing. Like we said, it's a probable cause hearing. What does that mean? One of the most important hallmarks of the preliminary hearing is that the Commonwealth's witnesses, their credibility is not an issue at this stage. So what does that mean practically? All right, so the hearing starts. The prosecutor is sitting at the one table. The magistrate says, I understand this is going to be a preliminary hearing today. Prosecution, are you ready to start? And they'll call their first witness, Officer so-and-so. And they'll say, Officer so-and-so, please tell us, what happened on July 4th, 2020. And then the officer will start to give a narrative, which is most likely, but maybe not, substantially similar to what they wrote in their affidavit of probable cause. You'll have some sense of what they're going to talk about. Whatever they say at that time, you, at that point, cannot technically attack their credibility. At least the judge has to take legally as fact whatever that officer says, okay? So the judge, as a human being, might say, this officer seems like he's full of shit. He seems like he may be drunk right now. There could be any number of things. Or any witness. It doesn't have to be a police officer. It could be an alleged victim in a domestic assault case. It could be an eyewitness to a burglary. Whoever it is. If they're being called by the Commonwealth, the law states that at the preliminary hearing, the judge has to take what they say as fact for determining whether or not the Commonwealth can articulate that a crime occurred. Their job here is not to substantively prove that it happened. That is what trial's for. This hearing does look a little bit like a trial. So like I said, it tends to confuse people. It tends to confuse people in the sense that they start to conflate it. There's a certain natural tendency as a person that when somebody goes up there and they're lying about you in court, there is a human reaction to just say, hey, that is a lie. This person's making things up, and like somebody needs to stop them, and you want to confront them. Unfortunately, you still got to remember what the rules are. At this stage is not the time to do that. But we're going to talk about there's going to be some things that you're going to want to do at this hearing if you think it's relevant. Okay, so at this preliminary hearing, like we talked about before, you're in front of the magistrate, right? This person may or may not be an actual attorney. They might not have any actual legal formal training. So you got to keep that in mind when you start to craft your arguments and everything else. That's not to say they just like give up or anything like that. A lot of times, what's good about the preliminary hearing from a criminal defense perspective is that, well, we don't have depositions in criminal practice generally. We don't have them as a matter of right. So that means that in getting ready for trial, when we get to the investigation phase, when we start calling witnesses and getting, our own version of events from people, they may or may not want to talk to us. And there's no legal requirement that they talk to us before court. So this might be your only opportunity to get the person where they have to talk to you. They have to answer your questions. And so really what the preliminary hearing, when you think about the low burden, whether there's probable cause, whether, the credibility determinations, that there are no credibility determinations, that the judge has to believe everything they say for the purposes of establishing probable cause, a lot of these hearings you're going to lose. That does not mean you're going to lose at trial, and that doesn't mean you should just waive or give up the hearing, because it kind of functions as a discovery device. It gets you an opportunity to ask some questions that were not included in the initial affidavit of probable cause, and you can start to establish certain things. Another reason too is because you might want to start to establish the record a certain way, and at the preliminary hearing, I can tell you this, that the DA has not really spoken to the officer ahead of time. So you're probably going to catch them the most flat-footed and the most cold on the case at this hearing. And so if you want to start to talk about, whether there's a suppression issue, and we'll talk about technically suppression issues are not relevant, and you will get objected if you start to ask a line of questioning that obviously is geared towards suppression. There's really no reason not to ask it, though. Just get objected to. But if you can get the information out and you get it ahead of time and you get it on the record, that's important, because you can then use that information to prep your suppression motion, your omnibus pretrial motion at the next stage. And we're going to talk about that in the future. So sometimes you're really just trying to set your pieces up. It's sort of, it's a strategy. It's chess to an extent. And so that's important. You really want to get this on the record. A lot of counties in Pennsylvania, they do not record preliminary hearings as a matter, of course. But technically you have a right to have the preliminary hearing recorded. And so, granted, there's no stenographer there. There's no, court reporter. So you're not going to get a transcript. If you want that, either you or your office has to pay for that to have that happen at the preliminary hearing. But you can always record it. Now, there are some questions of whether you can record it on your phone, because there's chain of custody issues and such and stuff like that. I can say with COVID-19, a lot of hearings have been conducted via Zoom, and nobody seems to have a problem. With Zoom, you can just record. And so nobody really has a problem, in my experience, with people recording that way, and it'll store it right on your computer. Just make sure you save it, because you will have to turn it over to the prosecution in reciprocal discovery. And we'll talk about that. That's something that happens at the next stage. But it's vitally important that you get a record of the preliminary hearing. Otherwise, there's really no point to it, because if your hope is that you're going to be able to establish a record and establish facts favorable to you, whether it's in a suppression argument in the future or whether it's in a defense strategy at trial, well, it doesn't really matter a whole lot if you don't have a record of it, because those people can just change their story and there's nothing to confront them with. And I also find that if people know they're being recorded, they act more professionally, and I think they act a little more honestly. Just the fact that they know that they were recorded in the past, they're not going to try to change their story in the future. They know what they said. But if they know they weren't recorded, and they know there's no one really there to contradict them, except for the defendant, whose credibility might be, somewhat hampered, it's just really important to have this hearing recorded. I highly recommend it. The only time I think you might not want to record it is maybe in a domestic violence case where the victim does want to testify against the defendant, but you think there's a good chance that she's going to change her mind in the future because she actually loves him, or for whatever reason. You don't want to lock her evidence in. If you think a victim who's very vitally important to the case is going to go south at some point in the future, and you'll know. I mean, when you do this job for long enough, people with mental health and substance abuse issues. Obviously, we represent them, but a lot of times, victims are also defendants. It's a day-by-day occurrence. So you want to think about those things, because it is important as far as strategy-wise as to whether or not to record. But I would always err on the side of recording the hearing. I can't think of any reason why you would not want to record and have a copy of it and be able to review it One other benefit of recording, at least in the COVID world, doing these hearings on Zoom, is that you're not entitled to discovery at the time of the preliminary hearing. So you're kind of going in a little bit blind. You just got that affidavit of probable cause. But sometimes prosecutors, they want to really sell their case at the prelim with some video, their surveillance footage, whether it's a retail theft or it's a domestic and the person thinks they got footage or something like that. When you record it and they share their screen, you record the video as well, so you get that discovery a little bit sooner. And that way you have it saved and you can review it. And so there's definitely a strategic benefit to that as well. So next, we talked about some of the particular evidentiary rules. One, that credibility of the Commonwealth's witnesses is not at issue. We talked about the standard of proof. They just got to prove this by a preponderant, by probable cause. Sorry, not preponderance of the evidence. And what that means is that it's not beyond a reasonable doubt. The way it kind of describes is like, there's a number of ways to describe probable cause. I hear a lot of judges say that the crime likely occurred and you likely did it. I don't really think that that's an appropriate articulation of that standard. I think that's even higher than what the standard actually is. That's more of a preponderance of the evidence description in my mind. But basically, probable cause is like, in my mind, it's like that it's possible that you did it. Not that it's been proven beyond all reasonable doubt. That's a trial standard. This would be like, say, in any crime, there were 4 possibilities as to what happened, okay? And in 3 of those, you did not commit the crime, but in one of them you did. And they've articulated all of that. Then technically, I would say at that stage, they have probable cause, okay? That's enough, because it's possible that you did it based upon the Commonwealth's evidence. And that just means there's enough evidence to hold the charge into court, meaning that the case gets bound over to the Court of Common Pleas for whatever county you're charged in. And we'll talk about the difference between the magistrate level and the Court of Common Pleas next. But that's where the law judges are. Those are the judges that decide, one, if you have a trial, that's where that would be in front of, and any suppression or legal issues would be litigated at that stage. That same analogy, if you have 4 possibilities, 3 where the defendant's not guilty, but 1 where he possibly could have committed the crime, then beyond a reasonable doubt, I would say, no, there's 3 reasonable doubts right here. All right, so that's the standard you're dealing with. Just because you lose a preliminary hearing does not mean that you have in any way been found guilty, or that it's been a judgment that you committed this offense. A lot of times, too, I've heard judges say, like, they'll give like a short little opinion, like, I'm going to find the charges over, but I'll admit, like, they'll say to the prosecutor, like, you've got serious problems with this case. I don't see how anybody's going to believe so-and-so. But they understand that their job is not to determine credibility at this stage. It's just whether or not somebody comes in and testifies to the elements of the crime charged. Now, the next thing I want to do is I want to give you an example of a case and show you what the arguments might be at this case, okay? So our client is Mr. Smith, okay? And Mr. Smith has been charged with aggravated assault against his ex-girlfriend, okay? And we read the affidavit of probable cause and we read the charges, right? Aggravated assault is defined as committing a serious bodily injury against another person. And then what's the definition of serious bodily injury? This is going off the top of my head, but it's basically an injury which results in protracted loss of a vital organ, or has like a reasonable possibility of causing severe harm or disfigurement or death. So it's pretty much, a very serious injury, right? So he's charged with 1 count of aggravated assault. He's charged with 1 count of simple assault, which just means the intent to commit a bodily injury against another person, okay? And so we read the affidavit, we go through and we say, okay, what did the officers do? They went out, it says on July 4th, 2020, we drove out to the residence because we got a call that there was an argument going on in this apartment. We spoke to the alleged victim, Mrs. Smith, and she said that, Charles Smith, our client, cut her with a Swiss Army knife and cut her hand, okay? And that she was bleeding profusely, had to go to the hospital and was significantly treated, and she was unable to use her hand for a period of time because there was a tendon cut in it. Okay. Now, the police didn't see any of this. So the police then come, the preliminary hearing comes, okay? And the Commonwealth calls Ms. Smith to testify. And they say, Ms. Smith, please tell us, what happened on July 4th. And she starts to give her side of the story. This is her on direct. This is a Commonwealth witness being examined by the prosecution's attorney, by the assistant district attorney, also known as the ADA, in the courtroom. And this is the story she gives them on the day of the hearing. She says, well, we got into an argument. We had both been drinking, and Charles slapped me in the face. And then the prosecution, but she says nothing about being cut by him, nothing about a knife, nothing like that. She's like, well, what about your hand? Oh, well, I cut that myself when I was trying to peel an avocado. All right. And then in that particular situation, you might not even want to cross-examine her. You don't want to give her a chance because at that point you're like, did she articulate all the elements, right? What element might she be missing here? If we're taking, and this is not going into credibility, this is taking what she said as fact for the purposes of the preliminary hearing. She has not articulated that your client has committed a serious bodily injury, right? She has not articulated that there was just a slap. At most, if we were to even believe that, which we have to at this stage, I won't say believe it, but we have to take it as fact, then all she has articulated is that there's a simple assault. But she has not articulated an aggravated assault because she did not allege that he committed a serious bodily injury against her. And so you could argue that to the judge, that based upon the standard of proof at this stage, even though it's a probable cause hearing, the burden is on the Commonwealth to show some evidence, to show someone that's willing to testify to the elements here, and they are missing the element of serious bodily injury. For that reason, there is not probable cause to hold the aggravated assault charge into court, and therefore it should be dismissed at this stage. So I want to go off that example a little bit to talk about hearsay, okay? For a number of years, there was this case from the Superior Court of Pennsylvania called Commonwealth v. Ricker, which was interpreted by the lower courts to mean that hearsay evidence was always admissible at trial hearsay evidence was always admissible at a preliminary hearing. And so what is hearsay evidence? Hearsay evidence basically, I mean, we could probably do another video on it. It's very complicated. But hearsay basically is an out-of-court statement being entered for the truth of the matter asserted. Generally what it means is that somebody said something, right? You didn't see it yourself, but somebody else told you something. It's generally how hearsay evidence comes in. Obviously, there is a way in which a person could present a hearsay statement of their own from before. We're not going to get into that. That's a little too complicated for today's purposes. But basically how it comes up in these domestic violence cases is the officer gets called in this case. And instead of Ms. Smith getting called, they'll call the officer. And officer, you went out on July 4th and you went to a report and you spoke to Ms. Smith. And what did Ms. Smith tell you happened that day? And he'll say, well, Ms. Smith told me that, she was cut by her husband. That's a hearsay statement. That's the officer testifying to the out-of-court statement of Mrs. Smith. Mrs. Smith is the one, if it happened to her, she should be the one testifying to that. And so for a number of years under this Ricker rule, that evidence was allowed. A lot of times the DAs would not even call the actual victim for the preliminary hearing. They would just call the officer and have him testify to everything because they would just say, Ricker allows us to hearsay everything in. That case was overturned by another case, Commonwealth v. McClelland, from the Pennsylvania Supreme Court. This was in the summer of 2020. And basically there the court said, no, you cannot bind a preliminary hearing solely on hearsay evidence. Hearsay is still admissible, but it can't be the sole basis of evidence. And it has to be inadmissible hearsay, right? In our example, that would have been inadmissible hearsay. There is some movement now, prosecution-wise, after the McClelland decision to try to get all these statements in now under a hearsay exception called an excited utterance. That is beyond the scope of this video. But your attorney, for the same reason you should have an attorney, they're going to be able to evaluate and analyze those statements and see whether or not there is a legal argument that they should be admissible at the preliminary hearing. And they'll evaluate whether it applies, whether there's an exception that applies that allows this hearsay in. And then even then, there might be confrontation issues, even though the confrontation clause in Crawford does not apply to a preliminary hearing. There's a post-McClelland argument that you still have to analyze that evidence because the preliminary hearing has to be predicated upon some admissible trial evidence. There has to be a showing that there's something here to present to the jury. Otherwise, people are getting their charges bound over based upon really no evidence. And even though credibility is not an issue, there's got to be something. There's got to, there's a due process consideration. So basically, you do need, in these cases, a victim, potentially, in my argument, to testify. And so that's going to be a big thing. You want to know part of your investigation pre-preliminary hearing and a lot of violent and a lot of these sort of domestic violence cases is, does so-and-so even want to testify anymore? And you might want to reach out to them and say, hey, I work for the defendant, would you mind, I know you spoke to the police, but I was hoping you could tell us too, what happened on this day. And a lot of times, people will say look, I was drinking, I was mad at him because, I thought he was cheating on me and, I took things too far and I may have exaggerated what happened on that day and I don't want him locked up and I don't want to proceed with these charges. That's important information to know as a defense attorney or as a defendant because it could be the basis. Now, some people tend to think there is this misconception that you press charges and that if you're the victim in a case, you get to decide what happens with the case. And unfortunately, that's not true. Once you call the cops and those charges are filed, it's out of your hands technically. The only thing you get to decide is whether or not you want to testify, whether you want to participate and help the prosecution in their cause. But conceivably, they could still prosecute the defendant with or without you, and sometimes that does happen. So that's something you kind of got to take into consideration. Might want to talk to an attorney about that. All right, so we talked a little bit about what the preliminary hearing looks like, the actual hearing, right? Calling the witnesses, the standard of proof, the evidence that's presented. One other thing you should think about too, should you take the stand at your preliminary hearing? The answer is almost always no. You should never take the stand at a preliminary hearing. You have a right to if you want to. Nobody can stop you. I mean, it's basically the same as taking the stand at trial. But there is no strategic benefit to doing it. Why? Because of what we talked about. There is no credibility determination as to what the Commonwealth's witnesses have testified to. So let's go back to our example of Mr. and Mrs. Smith in this alleged ag assault case. Say she testifies to all the elements. She says, yeah, Mr. Smith got drunk. He was mad at me. He always acts like this. And then he sliced me with the knife. And then Mr. Smith wants to go up there and say, no, she's lying. That never happened. She's a drunk. She was high on heroin at the time, and I didn't slice her. She fell over and cut herself. Okay, the judge can't consider any of that. That's just evidence to contradict her statement. Credibility is not an issue. She articulated a crime. The charges are going to get held over, 100%. And all you've done is now given your defense strategy away to the prosecution months before they're really entitled to even know anything about it. Really doesn't help you at all. There are some situations in which I've had cases where I've had clients testify at the preliminary hearing, and it has helped them. Charges got dismissed. But you got to analyze that ahead of time. I mean, that's not something you want to make a spur of the moment in the courtroom. I've seen people say horrible things on the record that get used against them, and it's once you say it, I mean, if the other side's recording it, there's a lot of, you don't want to testify at a preliminary hearing. There's really almost, I think 98% of the time, there's no purpose for you to testify. I would say I've done 1,000 preliminary hearings. I've maybe ever advised someone to testify, I think one time. But yeah, it's very rare that would be something that you would want to do. Okay, so what are some other considerations about the preliminary hearing? Now, we talked about the preliminary hearing itself, but there's also an option to waive the preliminary hearing. The reality is a lot of people actually end up waiving their preliminary hearing. I generally don't advise to do that, but there are some reasons to do it. I want to explain what it means to waive a preliminary hearing. Waiving a preliminary hearing does not mean you are admitting that you're guilty of the charges. It does not mean that anything they wrote in the affidavit of probable cause is true. Really what it is, it's an acknowledgement of how much the rules are against you at this stage, and that you realize the reality is, like, you're likely not going to win at the preliminary hearing stage. We know that. The primary purpose of a preliminary hearing most of the time is to, as a discovery vehicle, to find out what these witnesses are going to testify to, their temperament, and whether there's any issues or establishing a record. But we know the charges are going to get bound over. By waiving it, you're pretty much acknowledging, like, judge, they're based upon the rules, this low burden, the fact that no credibility determinations are in question today, and that you have to believe everything they're saying for the purpose of this hearing. Well, then, yeah, they're going to be able to articulate the crime. Doesn't mean I agree that I did this. I reserve my right to fight this at trial. So none of that ever comes up against you, right? So when you go to trial in the future, months down the road, and there's a jury there in the Court of Common Pleas, they don't get to bring up and say, oh, and this guy waived his preliminary hearing, so he's guilty. That's not admissible. So can't really be held against you. What it does prevent you, though, is prevents you from filing a habeas petition in the future challenging whether there's probable cause. Because technically you can have a preliminary hearing again. If you have a preliminary hearing and you lose, you can file again and do it in front of a common pleas judge. Basically saying, hey, judge, they made a mistake at the lower end on this. There really is no probable cause here. But the same rules really apply, except the evidentiary rules are a little different. I'm pretty sure hearsay is not just carte blanche admissible the way it was at the preliminary hearing. There's a stronger argument that witnesses need to be called. But yeah, so you're waiving your right to file a habeas in the future. Most of the time, it's not really a big thing to consider. And so what I talked about in other videos before is that you do want to have your kind of end game, your goal plan in mind early on so that you can take moves that are going to get you closer to that goal. So say, for instance, you're charged with a first offense DUI and you have no record. You've never been in trouble in your life. and you made one mistake, you were out, you know, you should have took an Uber, but you used some bad judgment, you know, and you had a couple too many, and you get pulled over, and, you know, and they take you down to do a breathalyzer, and you blew a .1. All right. In that case, you might be eligible for A or D. And so we're not going to go over all the terms of what A or D is, but basically in Pennsylvania, A or D is a first-time offender program under the discretion of the prosecutor, that if the prosecutor's like, look, we'll agree that if you do some community service, do these alcohol-safe driving classes, and stay out of trouble for about a year or two, we'll dismiss the charges. So there's no conviction. So you kind of, you know, it's a pretty good deal most of the time. And some counties, not all counties, but some of them condition upon, like I said, the DA gets to decide who gets A or D and who does not. And if the DA, they can condition the admissibility based upon waiving the prelim. So they might say, like, look, if you don't waive the prelim, then we're not going to approve you for A or D. And so either then, at that point, you can either go to trial or you can plead guilty. And A or Ds have mandatory jail time, which A or D gets you out of. So that might be one reason to waive a preliminary hearing. Definitely talk to your attorney, though. They're going to know the local practice, local customs. The other reason is if the person's incarcerated and there's bail is set at like $10,000 secured, and they're hoping to, you know, we talked about bail and the types of bail that can be set at the preliminary arraignment. Well, bail can also be modified at the preliminary hearing. At any time, you can make an oral motion to the magistrate judge and say, Judge, we'd like to be heard on bail. And sometimes you can negotiate that with the DA and say, look, my guy will waive the charges in if you agree to amend his bail from $10,000 secured to $10,000 unsecured so he gets out today. In that particular case where there's an agreement, magistrate's likely going to accept it. You still need the judge to accept the agreement. Otherwise, the judge could technically not and, you know, keep bail where it's at. But generally, if there's an agreement amongst the prosecution and the defense attorney as to what bail should be set at, most of the time, my experience, the DJ is going to go along with it. And so that might be a reason to waive, just to get the DA to agree to make that change. Another reason to waive is because they're going to dismiss charges. All right. So say our client's charged with ag assault and simple assault, and the DA says, look, if you waive the prelim, we'll just withdraw the ag assault. He can waive in the simple. There you might want to, because you're like, look, you know, it's a risk. If we go to have the hearing, maybe they can still get the ag through. But this way we know, we guarantee that we're going to get the ag kicked, and we really don't have an argument at this stage to get the simple kicked anyway. You are kind of giving up your ability to sort of get that preliminary cross-examination of their witnesses and, you know, check them for, you know, inconsistencies and their credibility and their, you know, their how well they testify. But, you know, you can still, there's other things you can do. You can obviously call these people and see if they'll talk to you outside of court. And to a certain extent, the discovery is going to give you a good idea as to whether or not, you know, how strong their testimony is. So those are some of the reasons why you might want to waive a preliminary hearing. But by no means, if they're not, in my opinion, you know, and obviously talk to your attorney, but if they're not offering anything, if they're not going to drop any charges and they're not going to help you out with bail and they're not going to help you get into a diversionary program, you know, I'd rather just have the hearing. Now they're going to kick and scream because they don't like to do hearings, even though the rules are on their side and they win almost all of them. My opinion is they're not going to give me anything, then I'm not giving them anything. I mean, we're going to have the hearing at the very least. You know, you miss 100% of the shots you don't take. So that's kind of my sort of my approach to preliminary hearings in a nutshell. Okay, so at the end of the preliminary hearing, whether you've waived it, whether you actually had a hearing, if the charges are all dismissed, then you're done. Your case is over. Your charges got dismissed. Now, the prosecution can refile the charges. So be on the lookout for that. A lot of times they don't, though. But technically, there's no jeopardy doesn't attach. So there's no double jeopardy concerns. Double jeopardy is only if you go to trial. You can't be tried twice. You can have more than one preliminary hearing, as long as they're within the statute of limitations for when the crime was charged. However, if the charges are held for court, meaning that you had a hearing, the judge heard their evidence and said, yeah, they articulated the elements, I'm binding the charges over into the court of common pleas, you're going to have to sign some paperwork. Or if you waive it, you're going to have to sign some paperwork. If you waive it, you got to sign a waiver of the preliminary hearing. You have to sign a notice that for when your arraignment's going to be scheduled, a summons for your arraignment. There might be some bail paperwork that you have to fill out if bail wasn't set at your preliminary arraignment, or if bail changed, you're going to have to sign new bail paperwork. And there might be a waiver of arraignment that your attorney might have you sign, which we talked about. That's a formal arraignment. So you already had your preliminary arraignment. They arraign you again in Pennsylvania. They arraign everybody twice. I don't know. It's a pretty meaningless court date. And that's it for the preliminary hearing. That's your preliminary, you know, that's everything you need to know about preliminary hearings to an extent. That's a sort of a nutshell. I guess the next video we'll do in the series is formal arraignments, because that would be your next technical court date. But a lot of times you're waiving that. You don't have to go to that. At least you're waiving your appearance. And then after that, your next court date would be a pretrial conference date or some sort of status date, at which point hopefully they've given you all the discovery in the case and you've had a time to, they've also made an offer in the case. But we're kind of getting ahead of ourselves. So that's preliminary hearings. If you have any questions or anything like that, feel free to leave a comment.